Okay, well, thank you very much, and it is an extreme pleasure, in fact, to see so many people working, interested, in fact, in the topic of agentification. And as you know, Michelle Everson and I have worked on this topic for quite some years, and we have tried for this conference also to make a further step in our research, and also to talk about, to see, in fact, agencies maybe also in a different function. So what we were going to talk about is the politicized administration, and I will explain you in a moment. Constitutional neglect, what we have called the court's, possibility, or the court's attempt to remedy that, and we will discuss some pitfalls that belong to this politicization issue. So, as the agency model was conceived, especially in the United States, it was a model that would allow, in fact, for policymakers to concentrate on their policy and the political aspects and delegate then technical aspects to agencies. So agencies in the literature also are very much conceived as a means to delegate technical issues to technical persons who will take care of that. Now, also in the practice of the agencies in the United States, you can already see that this, in fact, has been a bit broadened up in the practice, so that agencies do no longer carry out broad, mere technical tasks, but have over the years gotten broader tasks, and sometimes also making political choices. Now, this kind of model that has been introduced from the United States in the European Union, especially in the 90s, we see that actually also this has been very much of a concern in the European Union, and that also we had the Moroni Doctrine that focused, in fact, and said again and again, said in fact, and literature has repeated it again and again, that agencies could only be delegated strictly circumscribed executive powers. Now, we see recently also a phenomenon that agencies have been delegated broader powers than purely maybe the technical powers. And also, if you look very closely at the technical powers that some agencies have been delegated, then maybe in the end they're not so technical and would entail important political choices. So this then is a problem that we would like to address, or at least to discuss that, and whether in fact, and that's the question in our paper as well, whether it is desirable or necessary to have agencies evolve as maybe more political creatures. And there's still a question mark also at the conclusion of our paper, so that's also important to know in advance. And before discussing that, I have to discuss a bit, well, what we mean with the constitutional neglect. So interestingly, we see that the Lisbon Treaty has recognized agencies and has fully immersed them in the provisions of the treaty, especially judicial review. Agencies have become also have been mentioned. Agencies Act have been mentioned in the Article 263. Now, it's also true that there's no specific legal basis to create treaties. That was envisaged already in the before the Nice Treaty was discussed. Prodi did not find that a good idea, and he feared fragmentation of powers by introducing such a separate legal basis. So this has never appeared, but the Court of Justice has always said that actually it's no problem to create agencies, and it has recently also confirmed that in the ESMA case, because there are the specific policy, the legal base of the specific policy areas that could serve as a legal base to create agencies. So the absence of such a possibility in the treaty, and a legal base in the treaty as such, is not very problematic. We view, however, that it is problematic, especially with the broadened task that agencies have been conferred upon recently, is that we have this neglect of agencies where, in the treaty, where you would have expected them most, namely in Articles 290 and 291 of the Treaty of the Functioning of the European Union. This is about delegation of powers, and there is not a recognition that actually institutions, the legislator, can delegate powers to the European Union, to the European agencies. And that, in fact, that we have called, and I think this should work, yeah, the constitutional neglect. That's a detail, yes. So, and we said we can understand it, 290, because that was then, well, the powers that were thought to be a bit more the non-legislative powers, but with a broad character, which would, at those times, at least of the drafting of the Lisbon Treaty, against the Moroni Doctrine. But also surprisingly, even then, Article 291 does not make any mention of agencies. Not to say that agencies should also be mentioned in the comitology system, but you could have expected a separate paragraph in that article acknowledging that agencies also can be adopting executive decisions. Especially, it is rather well, odd because this whole system of legislative and non-legislative powers was meant to introduce a hierarchy of norms and was meant actually to be a rather exhaustive system for and simplification of EU acts. Now, this constitutional gap, we argue, actually the court has remedied in the ESMA case. ESMA case, and I don't have to explain you that, but just say that the Moroni case is upheld. The Court of Justice said, yes, Moroni is alive and kicking, but in fact, also at the same time mellows Moroni because it says, it recognized also that the powers that have been transferred, delegated to ESMA, are not of a very large measure of discretion. Importantly also, the court really considered that ESMA, in contrast with the situation in the Moroni case, ESMA is an authority that has been created by the EU institutions, by the EU legislator, and is an EU public body. Also importantly, and that's what the Court of Justice has said, is that judicial review is possible of these agency acts. So actually what the Court of Justice do, and it bridges the constitutional gap, it acknowledges actually that there's another possibility than the 290 and 291 to have binding decisions being adopted by agencies, and that in fact it is not included in 291, but they are not exhaustive. So actually there is a constitutional neglect, we argue, but this is, in the ESMA case, remedied by the European Court of Justice. It fills the constitutional gap. So in this way, the ESMA ruling, and we have called it Moroni 2.0, very fashionable also, that the ESMA ruling supports the further development of agencies and also actually would encourage broader powers to be delegated to agencies. And we argue, well, actually, the ESMA case is, the Court of Justice is adapting also to the functional reality. These kind of powers have been delegated to agencies, and actually it would have been surprising, especially in the view of the situation of the financial sector, if the Court of Justice would not have upheld, in fact, the possibility to delegate these kind of powers to ESMA. On one point, in fact, we have to criticize the Court of Justice, that the Court of Justice said actually that the powers that were delegated to ESMA were a very extraordinary case, which in fact was not covered by 290 and 291. And there we beg to differ with the Court of Justice, because actually there are some examples of powers that have been delegated to the European Commission, for example in the food sector, where in fact the Commission has powers also to adopt decisions in emergency situations. So the kind of powers that have been delegated to ESMA actually are also foreseen under the current 290 and 291, and have been actually there's examples for example in the food sector. Another point also that we can criticize the court's case law in ESMA is that the court disregards the value-laden nature of many regulatory issues. So in fact, the court says that well, this is kind of a purely managerial and scientific task, but it forgets, in fact, that probably it's illusionary to think that technical and managerial issues are not, in fact, would not embrace political issues. Importantly also, the court does not mention case law, so it says it upholds the Moroni case, strictly circumscribed powers. On the other hand, it says, well, ESMA does in any case not have a very large measure of discretion. On the other hand, it ignores also the case law of the General Court, where the General Court has said in relation to the Community Variety Plant Office that in fact this office is required to make, and I've quoted this on the slide, complex assessments, and it enjoys then a wide measure of discretion, the exercise of which is subject to limited review. Moreover, it held in another case that ECHA has broad discretion in a sphere where it involves political, economic and social choices on its part and where it is required to undertake complex assessment. So in the case law of the General Court, actually, the court has acknowledged that these kind of agencies make complex assessment and have to then balance and not, in fact, only maybe take pure technical measures. The Court of Justice, the General Court emphasized also in this case law that they can only examine this kind of measures whether a measure is manifestly inappropriate. Now, so this means that we have identified several pitfalls to the development, to the phenomenon that agencies are being delegated broader powers, together with the case law of the Court of Justice that has stimulate that kind of even practice. So we see that this case law of the case of ESMA does not coincide with the case law of the General Court, where discretionary powers are acknowledged that that agencies are carrying out these kind of powers, and also that it's problematic where, in fact, these agencies then balance, apparently, interest also, as the General Court says explicitly, there is limited review only. And that makes then us concerned about the adequacy of accountability mechanisms. And also, in the view of in light of all this, the balance between the independence and accountability becomes more pressing. The European Parliament has, in this context already, a proposal for an European Administrative Procedure Act and has inserted the principle of impartiality.
Oh,
this is you.
Me.
Okay, I thought this is going to be smoothly, but
yeah, this is the problem when you do a joint paper at distance. Because bear with me, I'm not quite sure which slide's coming when, but we'll get there. We'll get there. Now, Ellen started by talking about being honest and regarding the fact that we have a politicised administration rather than a depoliticised administration. And this does cause some problems, and we certainly picked this up in our Brussels meeting with the agencies, and largely Giandomenico Maioni's recent more critical work of the European Union does seem to be being borne out with the large degree of discretion and the greater demands made of agencies in terms of a political role, that they are moving beyond the balancing of interests and actually pursuing projects. And Giandomenico Maioni is Giandomenico Maioni and says it far better than I do, but the recent tendency, an understandable tendency in times of crisis, to disguise political projects as technical exercises, to try and negate or at least ameliorate some of the political conflicts that might arise in that respect also creates a problem for an agency administration. And the move ultimately from a depoliticized agency administration to an administration that is in some sense taking political decisions. Yes, agencies have strict mandates. Yes, the Commission tries to make those as precise as possible. And yes, the agencies strive on a day-to-day basis to try and remain within their mandates. But discretion, vagueness, the lack of political accord behind the mandate creates problems. So how do we deal with this? Next slide. Research. It's the academic refuge. I pose the conundrum and I say, right, we'll do some research on this, finding new measures of independence and new measures of accountability for independent institutions. But we also, I don't think we can disguise the depth of this problem. If we go to the next slide, ultimately, the use of agencies is always political. But it's the form of political that gives you the framework for response to, the question of how to control and construct and control an agency. If you go back to the New Deal, this is not about a depoliticized administration at core. There is an ideological impulse for the New Deal agencies. And the New Deal agencies are about redistribution. And they're about restricting individual rights within a very liberal American setting. So there is a political impetus behind the creation of those agencies, and there is also an immediate political blowback. The Administrative Procedures Act is immediate post-war, and it is an immediate re-establishment of political control over agencies through judicial review and assertion of individual rights. So that's one side. Our more recent model of agency administration, and also very strongly supported by Giandomenico Maioni a way back, was also ideological. And ideological in the sense that we believed market forces and the externalities of markets could be dealt with in a technical way because we were prepared to give market forces full rein. We believed in the market as a mechanism that could correct itself, so the agencies were all about just correcting the market forces within those logics. And that also gave rise to quite a clear scheme of independence and accountability. You give the clear mandate and you check the accountability around that mandate. Nice, sort of simple, she says, 30 years of research, but a general understanding of what's going on. If we move on now, though, and if we're talking about a politicization that is prompted within the European Union by the need to hide the fact that we're losing an ideology, that we have political conflicts, that we don't know how to move forward, then we have an issue of, well, what is the purpose of the agency? What is the actual particular political conundrum that we're dealing with? And I've popped a quote here, actually from Martin Shapiro, who is an American commentator on agencies and has always been very critical of the European model. And this specifically is a highlighting of a current problem of theorization of legitimacy under non-majoritarian political conditions. So you move away. We don't have majoritarian politics. We don't have agreement. We move away from the majoritarian model of politics to a deliberative model of politics, Good governance, deliberation, accountability, transparency, these are the words that we've been working with over the last 20 years. But ultimately, what does that mean? What does that all mean? What's pluralism, deliberation mean in terms of the goal that we are pursuing, the policy goal that we are pursuing, or the common good of the European Union? It asserts that we can find a neutral common good, that there is a good solution, that we all sit around the table and somehow the final decision doesn't reflect my interest or my ability to force my interest through because I've got this half of the table in some form of clamp, you know, some sort of political blackmail around the back or political deals on the left. That's not what's going on. Instead, we're coming to a good outcome. And that is the current driving force, I think, behind our, you know, the idea that there can be political agencies. But the world has changed. The world has changed, and Martin Shiro was correct to worry about those ideas of how you control politics 20 years ago. And it's certainly absolutely true now that we don't have a deliberative environment. We have a fragmented, interest-based, political arena out there. So when we say research, this is going to be difficult because it's finding a new form of how do we create accountability in an era of exceptionally contested politics in agencies and an independent administration that is now placed at the forefront of solving problems within a contested polity. And I'll stop there.